Breaking news right now. Former President Trump has appealed a judge's decision that required he answer questions under oath relating to his business practices. This is stemming from the New York Attorney General's civil investigation into the Trump Organization. Lawyers for Trump and his two oldest children argue testifying would violate their constitutional rights because their answers could be used in a parallel criminal investigation.
An appeals court has reinstated the gag order against former President Donald Trump in his massive New York civil fraud trial.
The decision comes just 2 weeks after an appeals court judge temporarily lifted a gag order issued by the judge in the trial. The order bans Trump from commenting on the judge and his staff presiding over the case that could have major impacts to his real estate business empire. NBC News justice and intelligence correspondent Ken Delanian is following the latest developments for us. So, Ken, what has Trump been saying about the gag order? And what is the court saying about its decision?
What's up, guys? Jack Mockler is here, so this has happened, guys. A New York judge ordered a sitting president to testify under oath in a state fraud case. And when Trump's lawyers tried to block it with an emergency appeal, the judge refused with no room for interpretation. No delay, no immunity, no special treatment. Just a flat order to show up and answer the questions, something never before seen in American history. Judge Arthur Engoron, the man overseeing this fraud case, didn't mince words. He told them the court will not tolerate delays designed to obstruct this process. Testimony will proceed as scheduled. That's not a ruling. That's a message, and the message is crystal clear.
Hey, Ellison and Kate. Well, in a happy Thanksgiving message to his followers on Truth Social, Mr. Trump called Judge Engoron a radical, left, Trump-hating judge and a psycho, and he called the judge's clerk, Allison Greenfield, politically biased and corrupt. And Mr. Trump later called the clerk disturbed and angry in a message that also went after the judge's wife, calling her Trump-hating. A court security captain said in a sworn statement last week that Greenfield, the clerk, has been receiving 20 to 30 calls a day to her personal cell phone and 30 to 50 messages a day on social media, LinkedIn, and to 2 personal email addresses. And the captain reported that about half of those harassing and disparaging messages to her were anti-Semitic. Trial Judge Arthur Engoron, who imposed the gag order, said he now plans to enforce it rigorously and vigorously, guys.
So, Ken, the gag order's back. Remind us what else is happening with this case and where we go from here.
Yeah, Kate, so we're expecting to see Mr. Trump on the witness stand on December 11th. And then after the holidays, the judge has set a January 5th deadline for written briefs. And then he's scheduled closing arguments in the case for a week later on January 11th.
Being president doesn't put you above the law. Not in this courtroom. Not in this case. Not today. Now, Trump's team is already talking about appealing to New York's highest court. They're going to try every legal maneuver they can think of to get out of this. But here's the thing that should terrify them. The appellate court that just denied their emergency request didn't just reject their arguments. They dismantled them. They called Trump's immunity claim procedurally baseless. They said, and I'm paraphrasing here but only slightly, that no citizen, not even a sitting president, is beyond the reach of the rule of law. Those words are going to echo through every other case Trump is fighting right now. Think about what this means. A sitting president, the leader of the free world, the commander-in-chief, is going to have to walk into a New York courtroom.
Testimony and dozens of witnesses, we are finally expecting to receive a verdict in Donald Trump's New York civil fraud trial. The judge has already ruled that the former president inflated his net worth on financial documents in order to receive business benefits. Now, Trump could be hit with several $100 million in fines. He could also receive a ban from conducting any business in New York State. Joining us now here in Studio 57 is CBS News campaign reporter and attorney Katrina Kaufman. Katrina, good to have you here. So what are we expecting from the judge's decision today?
As you just said, Trump could be fined hundreds of millions of dollars. They could put a lifetime ban on him in New York's real estate industry, bans on his sons, bans on his company. And this would also be rather uncommon for this law that they're using to prosecute him. It's very rare for victimless crimes to receive these type of punishments. So this could be a very, very big deal for Trump. He could lose his ability to do business in New York, which is really how he began.
Yeah.
And we also know that he is going to appeal this ruling. So today is not the end of things with this case.
Certainly.
Trump is going to appeal. He'll have to put down a substantial amount of money to do so as well.
Sit in that witness chair, raise his right hand, and swear to tell the truth. And then prosecutors are going to start asking questions. Hard questions, detailed questions. Questions about whether he personally directed the inflation of asset values to get better loan terms. Questions about financial statements he signed. Questions about whether he knowingly lied to banks and tax authorities. And he's going to have to answer, under oath, where lying has consequences. This is not some abstract legal debate happening in a law review article. This is real. This is happening. And the reason it's such a massive deal, the reason people should be paying attention even if they're sick of Trump legal drama, is because this has never happened before. We have never had a sitting president compelled to testify under oath in a state civil case. Never. There's no precedent for this. There's no playbook. We're making the rules as we go, and the rule that just got made is that the presidency does not grant immunity from state court proceedings when the conduct in question happened before you took office.
Based off of the judgment from the judge,
Based
not,
off of the
not for his appeal.
Not well,
right.
Based off of the judgment, he'll have to put down a significant amount because, I mean, Letitia James has asked for $370 million. We don't know what Judge Engoron is actually going to rule. But in order to proceed with an appeal, he'll have to put down a portion of that amount of money at least.
And we've heard, you mentioned victimless crime. We heard that certainly from Trump's defense counsel a lot, that they felt like this is political prosecution. And in any other case, that wouldn't be something that would be pursued. But because his name is Donald Trump, that's what's happening. Is that likely to factor into the judge's decision at all, given that he's already determined that he's guilty of fraud?
I don't believe that's actually part of that statute. There doesn't have to be a victim. It's also a victim, you could say, is the state. There is a lot of money lost because of what Donald Trump did with his business practices. And that's what Letitia James is asking for. It's called disgorgement, which means ill-gotten gains. So the state is trying to reclaim this money from him.
All right. Let's talk about another case because the former president is not.
Let me give you some context about why this particular case is so dangerous for Trump. This is the New York civil fraud case that's been winding its way through the courts for years now. At its core, the allegation is pretty simple. The New York Attorney General's office says Trump and his organization systematically inflated the value of their properties and assets. They would tell banks that a property was worth hundreds of millions to get bigger loans. Then they would turn around and tell tax authorities that the same property was worth much less to pay lower taxes. Same properties, same time periods, wildly different numbers, lying in both directions to benefit themselves financially. And here's the kicker. This wasn't just some mid-level employee cooking the books. According to prosecutors,
just focused on one legal case. Let's talk about the Supreme Court, because they are potentially going to make a decision about the immunity stay in Trump's January 6th case in Washington sometime soon. What more do we know?
So the justices do have a closed-door conference today. We don't know what they're actually talking about, but the stay is ready for a decision. Jack Smith had replied to Trump. Trump filed a final reply last night. And so now we're really waiting for the court to let us know if they're going to stay this ruling that Trump is not immune from prosecution, in which case that would keep the DC election interference case on hold, or they could even decide whether or not they want to take this case right now. So we would find out potentially even later today, possibly next week. It's hard to say. And we also have to remember there were arguments last week as well for the Colorado ballot disqualification case, which I feel like so much has happened since then that we've all almost forgotten about it. But they could be making a decision about that soon as well.
So we're waiting for both of those from the Supreme Court. Yes. We also have the Georgia election interference case that's going on, as well as
Trump was personally involved. He was directing his accountants and lawyers on what numbers to use. He was signing off on financial statements that contained those inflated valuations. This wasn't a mistake. It wasn't a misunderstanding. It was, if the prosecutors are right, a deliberate pattern of fraud spanning years and involving dozens of properties. Trump's defense has been consistent and, to be fair, not entirely without merit. He says real estate valuations are subjective. Different appraisers can look at the same property and come up with different numbers. That's just how the industry works. And besides, he argues, the banks did their own due diligence. They didn't just take his word for it. If they gave him loans based on inflated valuations, that's on them, not on him. That argument might work. It might convince a jury, but here's the problem for Trump. That argument requires him to be a credible witness. It requires him to sit in that chair and convince the court that he was acting in good faith, that the valuations were reasonable, that any discrepancies were just the normal give and take of the real estate business. And Trump is not known for being a careful, disciplined witness. He's known for saying whatever comes to mind, for exaggerating, for being loose with facts. That works great at a rally. Under oath, it's a disaster waiting to happen. The timing here is absolutely brutal for Trump. We're heading into a major election cycle, and now the sitting president is going to be in a New York courtroom answering questions about fraud. The optics are devastating. His opponents are already sharpening their knives, already planning how to use this footage in campaign ads, already framing it as proof that accountability is finally catching up with him. And his supporters are going to rally around him even harder, calling it a witch hunt, political persecution, an attempt to distract from his agenda. But here's the difference this time. He can't just tweet about it or hold a rally and complain. He has to sit there, under oath, and answer the questions. And that changes everything, because when you're under oath, every word matters. Every answer can be used against you. Every contradiction between what you say today and what you said in a deposition 2 years ago becomes evidence. And if you lie, even about something that seems small, that's perjury, that's a crime, that's a whole new legal problem. Let me take you inside the legal arguments that Trump's team made and why they failed so spectacularly, because this tells you something important about where the judiciary stands on presidential power. Trump's lawyers basically made 3 arguments. First, presidential immunity should protect him from having to testify while in office. Second, his duties as president make it impossible for him to take time away to sit for testimony. Third, forcing him to testify would interfere with his ability to govern, and the court rejected every single one of them. On immunity, the court pointed out something that seems obvious once you hear it, but clearly wasn't obvious to Trump's legal team. Presidential immunity is not a blanket shield that covers everything the president has ever done. It generally protects the president from civil lawsuits related to official acts, things done as part of the job of being president. But this case isn't about official acts. It's about Trump's private business dealings, his real estate empire, his personal finances, conduct that happened years before he became president. None of that is covered by presidential immunity, not even close. On scheduling, the court basically said what everyone who's ever had a job already knows. You make time for what you have to make time for. Other presidents have managed to deal with legal issues while in office. Bill Clinton sat for a deposition in the Paula Jones case while running the country. It wasn't easy, but it was possible. And the court noted that testimony can be scheduled around presidential duties. They're not asking Trump to testify during a national security crisis. They're asking him to set aside a few hours, maybe a day, to answer questions. That's not an unreasonable burden on the presidency. On interference with governance, the court was even blunter. They pointed out that Trump himself has set the precedent here. He's been holding rallies, playing golf, appearing at events, and doing all sorts of non-presidential activities while in office. If he has time for all that, the court said, he has time for a few hours of testimony. You can't claim that testifying would interfere with your duties when you're regularly doing things that have nothing to do with being president. This is why the appellate court called Trump's immunity argument procedurally baseless. It's not that the argument was weak. It's that it was so far outside established legal precedent that it shouldn't have been made in the first place. And the fact that Trump's lawyers made it anyway, the fact that they thought they could get away with it, tells you something about how they've been operating. They've been testing the limits, seeing what they can get away with, assuming that the normal rules don't apply to their client. And now, in this case at least, they've found a judge who disagrees. Judge Engoron, who's been overseeing this case from the beginning, has already shown he's not intimidated by Trump or his legal tactics. This is the same judge who fined Trump for violating gag orders, the same judge who sanctioned Trump's lawyers for filing frivolous motions, the same judge who has consistently ruled that the case will move forward no matter how many delays Trump tries to throw at it. When Engoron says testimony will proceed as scheduled, he means it. There's no more wiggle room, no more excuses. Trump has to show up. Now let's talk about what prosecutors are actually trying to prove, because understanding the substance of the case helps explain why this testimony is so critical. The New York Attorney General's office has been building this case for years. They've gathered thousands of documents, financial statements, tax returns, loan applications, internal emails, and what they've found, according to their court filings, is a pattern of deception that spans at least a decade. Take Mar-a-Lago, Trump's Florida estate. When Trump wanted a loan from Deutsche Bank, Mar-a-Lago was valued at hundreds of millions of dollars. The bank was told the property was worth somewhere in the range of several hundred million. But when Trump was filing taxes with local authorities in Florida, suddenly Mar-a-Lago was worth a fraction of that. Tens of millions, not hundreds. Same property, same time period, completely different numbers. And prosecutors say this wasn't an isolated incident. It happened across multiple properties, multiple years. A systematic pattern of presenting whatever number was most advantageous in the moment. And the evidence suggests Trump wasn't just a passive observer of this process. According to witness testimony and internal documents, he was personally involved. He would review financial statements. He would suggest changes to valuations. He would direct his accountants and lawyers on what numbers to use. In other words, this wasn't some rogue employee cooking the books behind his back. This was Trump himself at the center of the scheme, pulling the levers. Now, Trump's defense team will argue that valuations are inherently subjective, and they're right, to a point. Real estate appraisals can vary. Different methodologies can produce different numbers. But the difference between hundreds of millions and tens of millions for the same property at the same time, that's not a difference of professional opinion. That's fraud. That's lying. And that's what prosecutors are going to try to prove when they get Trump under oath. The testimony itself is going to be the most closely watched legal proceeding in years. Forget the Super Bowl. Forget the Oscars. The real entertainment is going to be in that New York courtroom when the former real estate mogul turned president sits down to answer questions about his business practices. Every word will be transcribed. Every answer will be analyzed. Every hesitation, every deflection, every "I don't recall" will be scrutinized by legal experts, political strategists, and the American public. And here's where Trump's personality becomes a major liability. He is not a disciplined witness. He never has been. In past depositions, he's contradicted himself. He's given vague, evasive answers. He's claimed not to remember things that any reasonable person would remember. He's attacked the questioners, the process, the entire legal system. And prosecutors have used those deposition transcripts against him in other cases. They've pointed to his evasiveness as evidence of consciousness of guilt. They've used his own words to undermine his credibility. Now imagine that dynamic playing out in a case where the stakes are even higher, where the financial penalties could run into the hundreds of millions, where the judge has already shown he has no patience for Trump's tactics, where every word Trump says can be fact-checked against documents he signed, emails he sent, statements he made. This is a nightmare scenario for someone who is accustomed to saying whatever he wants without consequence. There's also a political dimension here that can't be ignored. Trump has built his entire political identity around being a fighter, around never backing down, around punching back twice as hard when he's attacked. That persona works brilliantly for him in the political arena. His supporters love it. They see it as authenticity, as strength, as a refusal to be cowed by the establishment. But that same persona that works so well at rallies could be a disaster in a courtroom. Because in a courtroom, the rules are different. You don't punch back. You don't attack the prosecutor. You don't claim the whole thing is rigged. You sit there, you answer the questions, and you hope your lawyer has prepared you well enough to avoid walking into a trap. And if you can't do that, if you can't set aside the fighter persona and become a disciplined witness, you're going to have a very bad day. Let me walk you through the scenarios for how this testimony could play out, because the range of possible outcomes is enormous, and each one has dramatically different implications for Trump, for his presidency, and for the country. Scenario 1 is the best case for Trump. His lawyers prep him intensively. They drill him on every possible question. They coach him to be disciplined, to give short answers, to avoid volunteering information, to say, "I don't recall," when he needs to. And he actually follows their advice. He sits in that chair, he answers the questions carefully, and he gets through the testimony without creating major new problems for himself. In this scenario, the political damage is contained. His base sees him as standing up to persecution. The testimony doesn't produce any devastating admissions, and the case continues with both sides preparing for trial. But here's the problem with Scenario 1. It requires Trump to do something he has never done well. Be disciplined. Be careful. Think before he speaks. That's not who he is. That's not how he's operated for his entire adult life. He's a counterpuncher. He's an instinctual fighter. When he feels attacked, his reflex is to attack back harder. And in a courtroom, under oath, with a prosecutor asking hostile questions, he's going to feel attacked. The question is whether he can override those instincts. Scenario 2 is the more likely outcome. Trump starts off disciplined. He gives careful answers. He follows his lawyer's advice. But then the questioning gets tougher. The prosecutor pulls out a document he signed years ago and asks him to explain why the numbers on that document don't match what he just said. Trump gets frustrated. He starts arguing with the prosecutor. He goes off script. He says things his lawyers wish he hadn't said. Maybe he contradicts himself. Maybe he admits something he didn't mean to admit. Maybe he attacks the process in a way that plays well on Fox News, but damages him legally. This is the scenario that keeps Trump's legal team up at night, because once he goes off script, there's no telling where he'll go. He might say something that prosecutors can use against him in this case. He might say something that contradicts his testimony in other cases. He might create a perjury exposure where none existed before. And there's no do-over. There's no take-backs. Once the words are out of his mouth, they're in the record forever. Scenario 3 is the nightmare scenario for everyone involved. Trump completely loses his cool. He attacks the prosecutor personally. He claims the whole case is a witch hunt. He makes wild accusations about the judge, about the attorney general, about the deep state. He refuses to answer questions. He gives speeches from the witness stand. In this scenario, the testimony becomes a circus. The judge holds him in contempt. The legal consequences pile up, and the political fallout is catastrophic. Is Scenario 3 likely? Probably not. Trump's lawyers will do everything they can to prevent it. They'll remind him of the stakes. They'll warn him about the consequences. But anyone who has watched Trump over the years knows that this scenario is not impossible. He has a temper. He has a tendency to lash out when he feels cornered. And sitting in a courtroom, under oath, with a hostile prosecutor asking aggressive questions, that's a corner if there ever was one. Now let's talk about what this testimony means for the other legal battles Trump is fighting, because the implications extend far beyond this single case. Trump has been using similar legal arguments: presidential immunity, delay tactics, scheduling conflicts, in multiple cases. And if those arguments keep getting rejected across the board, then all those cases move forward too. The hush money case, the E. Jean Carroll damages case, the various federal investigations, every single one of them will demand Trump's time, attention, and money. And that's not sustainable. You cannot effectively govern while you're spending half your time in courtrooms or preparing for testimony or dealing with lawyers. Something has to give. Either Trump starts settling cases to make them go away, or he finds ways to delay them further, or he simply gets overwhelmed by the sheer volume of legal obligations. None of those are good options. The financial pressure is also real. Fighting multiple legal battles simultaneously is incredibly expensive. We're talking millions of dollars in legal fees. Trump has been fundraising off his legal troubles, sending emails to supporters claiming he's being persecuted and asking for donations. But there's a limit to how much money he can raise that way. And if he's paying lawyers to fight battles in half a dozen different courtrooms at the same time, that adds up fast. Some legal analysts have suggested that the financial pressure alone could force Trump to settle cases he would otherwise fight, to make deals he wouldn't otherwise make, because he simply can't afford to keep fighting on all fronts. The political fallout from this testimony is going to be massive, regardless of what Trump says. We're heading into a major election cycle, and now the sitting president is going to be in a courtroom answering questions about fraud. The opposition is already planning how to use this. They're going to run ads featuring footage of Trump walking into the courthouse. They're going to quote from the transcript. They're going to frame the entire election as a choice between accountability and corruption. Trump's supporters, meanwhile, are going to rally around him even harder. They see these legal battles as proof that the establishment is out to get him, that the deep state is trying to take down a president who threatens their power. Every court appearance, every testimony, every legal setback becomes ammunition for the narrative that Trump is fighting against a rigged system. And that narrative works. It energizes his base. It drives turnout. It makes his supporters more loyal, not less. But here's the thing about that dynamic. It works with his base, but it doesn't necessarily work with the broader electorate. Independent voters, the people who actually decide close elections, tend to be turned off by legal drama. They see a president spending time in courtrooms and they wonder who's running the country. They see a steady stream of scandal allegations, and they start to believe there must be some fire behind all that smoke. And if those independent voters break against Trump, the electoral consequences could be severe. So where do we go from here? Trump is going to testify, probably within the next week or two. We'll see how it goes, whether he can stay disciplined or whether he creates new problems for himself. Then the case continues. More evidence, more witnesses, eventually a verdict. And depending on what that verdict is, appeals. Lots of appeals. This could drag on for months or even years. But the key moment, the moment everyone is going to be watching, is that testimony, because that's when Trump has to sit there under oath and answer the hard questions. And whatever he says is going to matter. It's going to be analyzed. It's going to be used against him in other cases. It's going to shape public opinion. It's going to influence the election. And it might just determine whether Trump's presidency survives or collapses under the weight of its own legal baggage. This is unprecedented. This is historic. And it's happening right now. A sitting president compelled to testify under oath in a fraud case. The presidency has limits. Accountability still matters. No one, not even the most powerful person in the country, is above the law. That's the principle that just got affirmed in a New York courtroom. And now we're going to find out what it means in practice. Stay tuned. This story is far from over. The testimony is coming. The questions are being prepared. And whatever happens in that room is going to change everything.